Hi, my name is Andrew Meinzer of Meinzer Law Firm. We take care of people all across California who are planning to ensure that things go as they want when they die or become unable to take care of themselves anymore. Accordingly, the information that I'm about to provide is based on current California law. It's general information and it's not specific legal advice. Today, I want to continue to talk with you a bit about the type of property of two people in a marriage or registered domestic partnership. And this is the third video of a four-part video series. If you live in California, then you need to know about community property, quasi-community property, and separate property. That's true especially if you're married or in a registered domestic partnership. In the first two videos, we essentially defined community property, quasi-community property, and separate property. Here we'll pick up with changing the characterization of an asset and mixed characterization assets. The characterization of an asset as community property or quasi-community property or separate property can change. For example, the spouses or registered domestic partners could change the characterization of an asset from community property to separate property of one of the spouses, or vice versa. The act of making that change in the characterization is called transmutation. Also, an asset could be partially community property and partially separate property of one of the spouses or registered domestic partners. That would occur when the assets contributed toward acquiring that mixed characterization asset were partially community property and partially separate property. For example, a husband and wife purchase a house for cash. They pay 1/2 from their community property. The husband pays 1/4 from his separate property, and the wife pays 1/4 from her separate property. This also could occur in this situation. A wife inherits a house from her parent with the obligation to continue paying off the related mortgage. Then she and her husband spend community property employment income of the wife, or it could be of the husband too, to make mortgage payments and pay for repairs and maintenance of the house. That's another way that an asset could be part community and part separate. Planning ahead for transfers of assets after your death can be very complicated. There are many factors to consider, including who you want to receive the assets. Also consider how easy you want to make things for your family after you die. If you don't do this correctly, then you may create confusion or even conflict among your family members after your death. Hiring an attorney experienced with California transfers of assets after death is critical for obtaining the results that you need. In addition, the advice and guidance of an attorney experienced with transfers of assets after death is invaluable in these cases. At Meinzer Law Firm PC, we have over 20 years of experience helping clients with transfers of assets in California. Again, I'm Andrew Meinzer of Meinzer Law Firm. If you know that you need our help with estate planning, transferring assets at death, or even if you just have a question, please contact us and let us take care of you.